For 20 years, John Darnell worked as the neighborhood spray guy. His job was simple: keep the community parks and public spaces clear of weeds, using a handheld applicator of Roundup. Recently, Darnell was diagnosed with non-Hodgkin lymphoma. Darnell is currently one of over 65,000 active plaintiffs, waging a massive wave of litigation against Bayer, the corporate parent of Monsanto. The root of this legal wave traces back to a scientific disagreement that began in 2015. That year, the World Health Organization's International Agency for Research on Cancer classified glyphosate, the active ingredient in Roundup, as a probable human carcinogen. However, the United States Environmental Protection Agency came to the opposite conclusion. The EPA has continuously maintained that glyphosate is safe when used as directed and is not likely to cause cancer in humans. This direct contradiction between global scientific bodies and domestic regulators left consumers exposed to different safety standards depending on who they listen to, sparking a nationwide legal rebellion. Because the EPA deemed the chemical safe, Roundup's label carried no cancer warning. In response, plaintiffs began suing under state laws, arguing that the company failed to warn them about the health risks associated with the product. Their cases gained momentum in 2024 and 2025 as new research emerged. These studies showed the complete formulation, with toxic surfactants called POEA, contributed to liver damage, brain damage, and developmental harm. State-level juries, presented with this new data, hit Bayer with massive mega-verdicts, including awards of $1.56 and $2.25 billion. Appellate judges later stepped in to reduce those staggering amounts. Yet even as damages shrank, courts upheld the underlying corporate liability. A continuous string of state court losses took a manageable legal headache and turned it into an existential corporate crisis, pushing Bayer toward the brink of financial collapse. To stop the bleeding, Bayer deployed its strongest legal defense, a federal statute known as the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. The company's core argument relies on express preemption. They argue that because the EPA formally approved the Roundup label without a cancer warning, any state-level jury demanding such a warning is illegally overriding federal authority. Initially, federal appellate courts weren't buying it. The 9th and 11th Circuit Courts ruled that state failure to warn claims perfectly parallel federal misbranding laws, meaning states still retain the right to protect their citizens from harmful chemicals. Then, that consensus shattered in August 2024. The 3rd Circuit Court issued a decision in Schaffner v. Monsanto, ruling that because a manufacturer cannot legally alter an EPA-approved label, all state tort claims regarding the warning label are preempted by federal law. This created geographic chaos across the lower courts. A plaintiff might win $1 billion in one state, but be dismissed in another. To resolve this untenable split, the U.S. Supreme Court agreed to hear the Darnell case to establish a single nationwide standard. A dispute over a gardener's warning label escalated into a high-stakes constitutional battle over whether states hold power to regulate public health. While awaiting the Supreme Court's decision, Bayer engineered a parallel strategy for financial containment, a $7.25 billion global settlement framework. The settlement's tiered structure caps compensation based on demographics. Occupational users could receive up to $165,000, while residential users are capped at $40,000. In response, 14 law firms are fighting to block the deal, pointing to a convoluted 11-step opt-out process that blocks independent trials. The settlement functions as a calculated financial labyrinth designed to lock thousands of claimants into strictly capped payouts before the Supreme Court rules. Just as the Supreme Court prepared for oral arguments, the political landscape shifted beneath the entire case. President Trump signed Executive Order 14387. The president invoked the Defense Production Act, officially declaring the domestic supply of elemental phosphorus and glyphosate to be critical to the national defense. The administration finds these chemicals essential for agricultural productivity, military munitions, and semiconductor manufacturing. Buried within the order is a sweeping directive. It mandates that federal agencies must ensure their regulations do not place the corporate viability of domestic producers at risk. By legally categorizing Bayer as an indispensable defense contractor, the executive branch handed the Supreme Court a national security justification to end the ongoing state-level lawsuits. Bayer's survival strategy then opened a final front in the U.S. House of Representatives, where aggressive lobbying efforts targeted the 2026 Farm Bill. The proposed bill attempts to write federal preemption directly into law permanently. In response, a bipartisan coalition, led by representatives like Chelly Pingree, introduced an amendment to strip that immunity and preserve local autonomy over toxic chemicals. Every maneuver, the settlement caps, the executive order, and the Farm Bill, converges on the impending Supreme Court decision in Monsanto v. Durnell. The impending decision determines if federal economic and security interests can legally erase a citizen's right to hold a corporation accountable for their health.